All right, hello everybody. It's Allison Robinson here again with Juniper Trails Life on our business beat. And today with us, we have Jerry Dorn of Anderson, Dorn and Rader, a law firm here locally in town in Reno, specializing in estate planning, trust wills, and asset protection. Hi Jerry, how are you today?
Good. How are you, Allison?
I'm doing well. Are you weathering?
Happy Friday.
Yeah, you too. Are you weathering the COVID storm okay?
We are. We're surviving and adapting as best we can, just as is everyone.
Yeah. So why don't you tell our viewers today just a little bit about Anderson, Dorn and Rader, the history of your firm, and then a little bit more about yourself.
Sure. The firm was started in 1995, initially by my former partner, Brad Anderson, who has since retired. I joined Brad in 1996, became a partner in 1998. I've been in practice since 1995, practicing exclusively in the area of estate planning and estate and trust administration.
Excellent. So right now, I would imagine people, probably your clients, are contacting you just to make sure that their estate and their trusts and so on and so forth are the way set up the way they should be in light of this COVID crisis and people sort of, getting sick rather prematurely. What advice right now do you have to our viewers that may or may not, have a trust or an estate planning instrument in place?
Yeah, it certainly has brought estate planning to many people's awareness. There's a lot of fear out there, a lot of uncertainty, a lot of concerns for one's mortality. And that has brought a certain number of people to our firm inquiring about a review of their estate plan if they have an existing estate plan, or for those who don't have an estate plan, people who are anxious in getting their affairs and their estate plan in order. It's something that should be on everybody's mind, absent a pandemic, but for a lot of people, this has been a real eye opener and has made them come to bring those documents back front and center and have everything reviewed to make sure that everything is in order, so that they can have peace of mind that at least that particular area they have control over and they have taken care of.
Exactly. So how long, when somebody comes to you, how long typically does it take your firm to, if they have a plan in place and they ask you to review it, how long does it take you to review it, to come up with a proposal, and then actually draft new documents if necessary? What's the time frame on that?
If it's just a basic will or trust-based estate plan, we can typically review that at the consultation, unless there's something a little more complex and sophisticated. But we can usually do a review at that meeting, make recommendations based on what the client is telling us their goals and objectives are and what their fears and concerns are. And if they decide that they want to move forward and restate their plan, typically our process is anywhere from 4 to 6 weeks to completion. Typically involves a minimum of 3 meetings. The first meeting, the consultation, fact-finding meeting. We call it the discovery meeting. We make recommendations. Should they decide to move forward, we go to draft on the documents. They then come in for a review and signing meeting. They bring us their asset information. Even if they have an existing estate plan, we want to make sure that we have a complete and thorough asset file for them. We review everything to see how things are titled, make recommendations on beneficiary designations for such assets as retirement plans, life insurance policies, and annuities. We review that information at their signing meeting, and then they come back in to execute any funding documents. So if they have real estate, for example, that needs to be transferred into the trust, we prepare the deeds for that. If they have business interests, we prepare the assignments, and we provide them instructions and assistance on transferring all of their assets and designating beneficiaries on assets that pass by way of beneficiary designation. So we're really soup to nuts. We provide unlimited assistance in funding, and we don't charge our clients for phone calls. I think that's one of the things that makes us unique. We actually want to foster communication with our clients. We don't want them to have a question, but then be fearful that when we answer the phone, they're going to hear that clock ticking in the background and get that annoying bill for,
billable hours, right?
Exactly. Yep. We don't do that.
So someone, who might find this whole process daunting, and they don't know really where to begin. They know that they may have a trust, they may not have a trust or will. They can just throw everything at you. You'll take care of everything for them. They just need to provide the documents as you request. You'll give them a laundry list of everything that they need to provide you. And then you'll take care of everything else, so they don't have to really worry about going to a bank or going to a notary or going to whatever they may have to go to. You can do it all for them.
We can do most everything for financial institutions, because they're constantly changing their applications, and because we can't get a power of attorney to transfer somebody's bank account into their trust. So for accounts, typically that the client will need to present to the bank, it's a very simple process. The banks are used to seeing this. It's very common. You go in and see somebody in the accounts division, tell them that you've created a trust and you want to transfer your accounts into the trust. For most financial institutions, you don't even have to close the existing account. They can use the existing account. You just sign a new signature card. The trust doesn't need to appear on the checks, printed on the checks. So it really is a simple process, but there are certain things that there is a certain amount of legwork that the client needs to do on the funding side. We handle the recording of the deeds. We handle the submission of beneficiary designations. For clients who have a financial advisor, we'll work directly with the financial advisor and pull them in to prepare the documents necessary to change the accounts into the name of the trust. So we take as much of the legwork out of it as possible, but sometimes there's still a little additional legwork that the client needs to undertake in order to get the trust funded.
Right, understood. So then looking forward, sort of a forecast, into next year. We're in an election year now. Depending on what happens in November, the administration may or may not change. If the administration changes, there's a lot of talk about what may happen to asset protection in terms of capital gains tax, in terms of a death tax, and so on. So what are your views on any of that at the moment, and what should people be doing now? What could they think about right now to address some of those potential concerns, so that if there is a change in any of this stuff, their assets are protected?
So the regime currently is, for estate tax purposes, we're talking federal estate taxes, there's an exemption of $11,580,000 currently in the year 2020. If Congress does nothing on January 1st, 2026, that law sunsets and goes back to prior law, which was $5 million as adjusted. So we have that looming in the future. If we get a change of control, and maybe even if we don't get a change in control, somebody's going to have to pay for all of this debt. It's inevitable, and I really don't, no matter who is in control, see this exemption amount remaining at this higher level. And certainly, if we see a change of control in November, it's very possible that we could see legislation lowering the estate tax exemption amount considerably as soon as next year. And one of the things that is on the table too is getting rid of the filibuster power in the Senate, so that tax legislation moving forward, potentially as early as next year, could be made with a simple majority vote of the Senate. So very, very good chance we're going to see lower exemption amounts. Anybody's guess what they'll look like. Looking at the tea leaves in previous Democratic budgets, 3 million, 3.5 million, maybe a carryover cost basis regime. Currently, if you pass away with appreciated assets in your estate, they get a step up in basis equal to fair market value at death, so that the family can sell assets without any capital gains exposure. But what it does mean for my wealthier clients is, we're going to have to look at potentially engaging in some gift tax planning and taking advantage of this higher exemption regime now while it's here, because it could be here today, gone tomorrow. So I do anticipate a large wave of clients toward the end of the year, similar to what we saw back in 2012 when the estate tax exemption was going to go from $5 million down to $1 million. So I do anticipate a lot of people inquiring. We have our list of high net worth clients that we're going to be reaching out to for consideration and making some gift planning toward the end of the year. Yeah. The sooner the better.
Sooner the better, for sure. Now, I know that one of the things that you offer currently to people that don't know much about estate planning or haven't really thought about it, you have some webinars, and you do that monthly. September, I believe, is your next set of webinars. Do you happen to have those dates that we can share with our viewers?
Yes, yes, they're the week of September 7th through the 11th. They're at various times. For anyone who's interested in attending one of the webinars, I recommend that they go to our website, which is probatebusters.com. And we have a list of all of our webinar dates and times. You can register right there at the on the website. And again, we do them monthly. These are in lieu of the in-person live seminars that we've been doing for the last 25 years because of the COVID pandemic. The hotel meeting rooms were closed. They opened in July. We tried to do one, but we had two people sign up. So we've taken them off the calendar for the foreseeable future, and we'll continue with just the webinars until we get further down the road and people are a little more comfortable assembling in larger groups.
Sure, sure. And that's going to be free advice to people. If they attend these seminars, they'll get a lot of great information that'll arm them and help them go forward and either talk to you in the future, or if they already have someone, they can talk to their own personal attorney. But this,
absolutely.
Yeah.
Absolutely. That's one of the things that we really pride ourselves on, is really educating our clients and the public on their options. Okay, wills versus trusts, education on probate, and education on the advantages and things that you can accomplish with a trust. And people are able to come to the seminar as opposed to coming into a consultation room, which can be a little more intimidating. They can come, they can learn about estate planning. When they come in for their consultation, they're armed with that knowledge. They feel much more confident in making decisions. And ultimately, when they're done with the process, they understand it to a level to where they really have a great deal of comfort with what they've done and that it satisfies their needs.
Excellent, excellent. Okay, well, I think that about wraps it up. I think there's a lot of great information for our viewers. And again, probatedusters.com.
Probate Busters. That's right.
Busters, excuse me.
that's the cheeky way to get us. You can also find us. It's the same website, just a different URL at wealth-counselors.com.
Excellent. Excellent. Well, thank you, Jerry. I appreciate taking the time to chat with us this morning, and that's great information for our viewers. And just stay healthy in this current health crisis that we're in.
Always a pleasure. Thanks for having me, Allison. You stay well as well.
Okay. Thanks, Jerry.
Okay. Take care.